prosecution barrister and the defense barrister, usually with solicitors behind them taking notes.
What's going on, y'all? Attorney Tom here. Today I'm going to be reacting to a video about the Crown Court. The Crown Court is essentially the English and Wales equivalent of a criminal district court where criminal cases are tried. And while it is my understanding that there is a lower form of courts in the English system called magistrate courts, and these courts do handle some criminal matters, if a case needs to go to trial, it gets elevated to the Crown Court. So while we are right in the middle of reacting to the trial of Tim Heidecker on this channel,
around watching these movies.
Please direct your comments to the bench and not to other counsel.
How would you describe it, Judge? A man who sits around watching movies all day. These Sleepless in Seattle Hobbit movies. Is that a winner?
It's better than killing people at a
proceed.
music festival.
That deserves a punishment right there. And
I thought this would be a great opportunity to observe how the criminal justice system works in England and Wales and compare and contrast the differences. I imagine there's going to be a lot of similarities because American jurisprudence derives from this system, the common law system, which we took from the British. Let's jump right into it.
I am the judge, and it's my job to interpret and uphold the law.
Yeah, so I know what the judge said might seem minor, but this is actually true, and it's important to note that this is the same in America as well. So the judge's job is to interpret the law, answer any questions of law. The jury's job is to answer questions of fact. What I think a lot of people don't necessarily understand is the jury does not interpret the law. They only interpret the facts. The judge is going to be the one who is going to be answering questions of law throughout the entire trial. A question of law might be something simple as, hey judge, is this piece of evidence admissible? Which is a decision about the rules of evidence, a question of law, which would then decide what facts the jury then hears. These are two separate things. All right, let's keep going. We're learning things.
People present during a trial at the Crown Court are the
I don't really know what an usher is. We have court clerks.
prosecution barrister and the defense barrister, usually with solicitors behind them taking notes.
So this is the first big difference we see. In England, there are two different types of lawyers, barristers and solicitors, and they are completely separate. Barristers are essentially trial lawyers. These are the individuals who speak at court. Solicitors are kind of like transactional lawyers. These are the people who are behind the scenes. They don't go to court, or they don't speak in court, but they are gathering evidence. They do document reviews. They put together business deals. They write wills, that kind of stuff. And to be totally candid with you, I think the American system is way better for individuals who want to pursue a career in law. In America, we don't have these differences. You are a lawyer. So in America, as a lawyer, I'm licensed to do everything. I can defend someone in criminal court. I can be a trial lawyer in personal injury court. I can put together a business deal. I can execute a will. I can do it all. There's no difference. It's something that I would be really curious to know, having never been to Britain and knowing a barrister and or a solicitor, is for barristers, going to trial is such a narrow focus. I mean, how often are you actually in trial? I myself pride myself on being a trial lawyer, but 99.9% of the work we do is outside of the courtroom. So where does the line between barrister and solicitor stop? Or where is the line? 1 point for America. Before anybody writes a mean comment, forgive me, I'm just trying to have fun, but just from an outside perspective, I think our system's better.
Solicitors behind them taking notes. And the jury. The defendant will sit in the dock and be present during the trial.
So that doesn't happen in America. In America, the defendant is going to sit at the counsel's table with the defense lawyer. Let's go back a little bit.
Defendant will sit in the...
Yeah. So if you can recall from the trial of Tim Heidecker, Tim is sitting at the same table as his lawyer. And even though he fires his lawyer on the very first day, that is where he sits. Let's keep going.
The dock and be present during the trial. It is at my discretion whether or not there is a public gallery.
So that's different in the United States. Judges generally don't have a choice whether or not to allow individuals into the courtroom. There's essentially a right to having an open court system where anybody can come and watch. The parties can make that trial not accessible to the public in person, but generally if you do that, you have to compensate in another way, such as having the event on television or live streamed so the public can watch.
After the jury has been sworn in, I address them directly. I inform them that it is for them to decide if the evidence they are going to hear proves the defendant's guilt. I also inform them that it is their job to consider the evidence, not the law, and that I will guide them if necessary on points of law.
Same thing in America, what I was just speaking. The jury is the finder of fact, and the judge answers questions of law.
I am the next person to address the jury. I introduce myself and explain that I appear on behalf of the prosecution in this case, and my learned friend, who I name, appears on behalf of the defense. I then outline the prosecution case, explaining each offense and the evidence the jury will hear in proving this.
Which would be the opening statement.
I will state that it is the prosecution's responsibility to prove beyond any reasonable doubt that the defendant is guilty of the offense that they are before the court for.
Same standard beyond a reasonable doubt, same standard that we use in America for proving criminal cases.
I will introduce the first prosecution witness. I will then ask a series of questions with regards to the evidence they have given in a statement to the police. This is known as examination in chief.
Very interesting. So the prosecutor barrister, is allowed to give his opening statement and then move on to his case in chief. In America, the prosecutor gives their opening statement, then the defendant has the right to give their opening statement. In the past, it was the prevailing theory to just go ahead and let the prosecutor present their case in chief before the defendant got up and began their case. But this has been totally disproven, and now the dominant trial theory for the last 30 years or so has been to address the jury immediately after the prosecution gives their opening statement. So the prosecution gives their opening statement, then 99.9% of the time, the defense will give their opening statement, and then the prosecution will follow with their case in chief. And the purpose for this, at least the thinking in the American system, is juries are regular people. They develop biases. So if you don't allow the defendant to give their side of the story from the very beginning, well, by the time the defense gets up there to give their statement, it might already be too late. The jury might already have made up their mind. First impressions are so important. Also, we don't have to wear the wigs or the big robe. We just wear suits.
On completion of this, the defense may ask the witness a series of questions. This is known as cross-examination. Upon completion of the cross-examination, I may be given the opportunity to ask a further series of questions to the witness. This is known as re-examination. I will continue to call witnesses until all the witnesses have been called.
Their witnesses are standing. Usually witnesses sit in every courtroom that I've been in, at least.
The stand. I will announce to the court that this is the case for the prosecution.
At this point in the case, I may make an application of no case to answer to the judge, stating that the prosecution has not raised sufficient evidence to prove that the defendant has committed the alleged offence.
So this is very similar to the American system as well. After the prosecution gives their case in chief, you can make a motion or move for acquittal. Remember, it is the prosecution's burden to prove every element of the alleged charge beyond a reasonable doubt. So let's just say there's 5 elements and they proved 4 out of the 5, but they didn't prove 1. Well, then you can make a motion, and if the judge determines that they did not even put forward any evidence that a reasonable juror could consider beyond a reasonable doubt, or they didn't put on anything that alleges that fact, then the judge can just go ahead and dismiss the case. Not dismiss the case, acquit the defendant. There's a big difference. But these are generally very rare.
If he finds in favour of my application, he will instruct the jury to find the defendant not guilty, and then he will release the defendant. This is an acquittal. If the judge considers the prosecution has raised enough evidence, then I will continue with my case. As with the prosecution barrister, I will introduce the witnesses. However, at this time, they will be giving evidence for the defence. This will follow in the same procedure of examination in chief, cross-examination, and then re-examination. At the end, I will declare that was the case for the defence.
They didn't say anything about her being able to give an opening statement, the defense giving an opening statement.
I then stand and give what is called my closing speech, where I outline the prosecution case and try to persuade the jury that the defendant is in fact guilty.
I then stand and give my closing speech, outlining the defence's case and trying to persuade the jury that the defendant is not guilty.
So we call this a closing argument. Same thing. The only thing I would note is these individuals have not moved the entire time. Generally, at least in my personal experience, we have a little bit more freedom to walk around the well. You don't get close to the jury box and you have to ask before you approach the bench, but generally we are at least allowed to walk within an arm's length of the counsel's table. And sometimes we do this for dramatic effect, get closer to the jury. We don't want anything blocking us from the jury, such as a table. Just kind of minor things, I guess.
I will then sum up all the evidence. I will direct the jury on the legal issues and what the prosecution has to prove if they are to find the defendant guilty. I will give them the legal options available, reminding them that if they are not sure, they must find the defendant not guilty.
We then retire to make our decision. Once a decision has been reached, we return, and as foreperson of the jury, I announce the jury's verdict. If found not guilty, the defendant is released.
If the defendant
Yeah, same as America.
is found guilty, I will make a statement in mitigation to the judge. The judge will take this statement into account before sentencing.
I thank the jury for the service that they have provided. If the defendant is found not guilty, I will release the jury from the court. If the defendant is found guilty, I will move to sentence him in a straightforward case. It is likely in that instance that the jury will remain in court. I may, however, postpone sentencing where other factors are to be considered. This can be particularly appropriate where there have been contentious issues or where the defendant's background is likely to have a significant impact on the sentence I pass.
Real quick before I'm getting into my main point, everybody always stands when the judge arrives and when the judge leaves. Same as it is here. But the reason why I pause this video is because in America, it likely depends on what jurisdiction you're in, what crime you are charged with, as to who determines your sentencing. Sometimes you can opt to have a judge conduct sentencing. Sometimes you can opt to have a jury do your sentencing. They didn't really get into too many details here on if the judge is the one doing the sentencing or the jury, or maybe it's a hybrid system like we have where maybe the defendant has the right to choose. Just something to note. All right, thanks University of Derby. Okay, so that's it for today's video. If anybody out there knows anything about the difference between barristers and solicitors, I'm actually very interested to learn more about this. Please make sure you hit that like button, leave any questions, comments, concerns down below. This was actually a very fun video to make. I hope y'all enjoyed it. As always, my goal is to make content worthy of your time. Consider subscribing to this channel if you want to be a part of this community. I think we just passed 319,000 subscribers. All right, y'all. Talk to you later.